Authority from the University of Regina in 2019 and holds her Urban S certificate. So, Chris, I'm going to hand this off to you and look forward to your presentation.
Thanks, Colin. Good morning, everyone. Um, First, I would like to say thank you to SARM and Adam and Colin for having me speak this morning to discuss the amendments for the Municipalities Act from the passing of Bill 194 on July 3rd, 2020. And again, my name is Chris, and I'm a municipal advisor with the Ministry of Government Relations. See if I can get this working. Sorry. All right. So today we will be discussing some key topics um, of the Municipalities Act that received amendments in July of 2020. This is not an exhaustive list of all the changes, but you are encouraged to review the Municipality Act Amendments Bulletin as well as the full chapter, which are available on Publication Saskatchewan. The key areas that we'll be covering today are administrative efficiencies, improving local governance, increasing accountability, protection from reprisal, dispute resolution measures, assessment, board of revision, and taxation, and some miscellaneous clarifications. Throughout the presentation, you may hear me say that regulating authority or regulation making authority has been added to various sections in the Act. What this means is that particular section now has the ability to be changed in the future by amendments that are made through the municipality's regulations. Simply put, no immediate change has been made to the section, but the ability to do so in the future is now there, and any changes would be made within the regulations. First, we'll review a few of the amendments to the Act that allow for administrative efficiencies. Starting with contact information, this amendment allows for greater flexibility in receiving and sending information, including electronic means. As noted in the slide, throughout the Act, the words contact information has replaced other references of address, phone number, fax number, etc. for consistency. Another efficiency to note is the definition of mail has been added to permit for email or other means of electronic transmission. This too provides greater flexibility in receiving and sending information. Consent is required from the person receiving the email. Email or electronic transmission does not replace documents required to be sent by registered mail or served. Municipalities now have the ability to send notices for bylaw violations and contraventions through email. Adding amounts to taxes. Section 405 has been amended to deal with adding amounts to taxes, or what is commonly referred to as custom work. Before the amendments, any amount owing for custom work could only be added onto taxes at the end of the calendar year. However, with the amendments, municipalities now have up to 12 months after the service or custom work was performed to add the cost to taxes. Remember, this is for work agreed to by the ratepayer and the municipality. Having a written agreement and acknowledged by a resolution is always a best practice. A new section has also been added, section 405.1, that allows municipalities to enter into an agreement with a landowner to add unpaid amounts for work or a service over multiple tax years. Again, this is only by agreement, and a best practice would be to have the agreement in writing and acknowledged by a resolution. If a municipality enters into such an agreement with a landowner, they also have the ability to register an interest against the parcel of land in the Land Titles Registry through ISC. The interest would remain in place until the full amount of the cost of the work or service has been paid, even if the ownership changes. The next few slides that we'll be going over will cover the amendments made to the Act to improve local governance. This is probably everyone's favorite in the RM, road maintenance agreement. When talking about improving local governance, we'll start with section 22 regarding road maintenance agreements. The section had some noteworthy changes, one of which allows for a municipality to enter into a road maintenance agreement using an alternative schedule of charges or fees from those prescribed in the regulations, if they are applied consistently for all other agreements in the municipality, and of course, both parties agree. To ensure that an alternative fee schedule is applied consistently, a best practice would be for council to develop and adopt a written policy. If both parties do not agree to the alternative fee schedule, the municipality could still require a road maintenance agreement as they could before, but the prescribed fees must be followed. You can find the fees in the municipality's regulations, and those are updated every 2 years. If an alternative fee schedule is used, neither the municipality nor the other party would have the ability to apply to the Saskatchewan Municipal Board for a decision regarding any issues that may arise. The agreement must contain provisions for dispute resolution. Lastly, the minister may require reporting of road maintenance agreements. A significant section was added to the Act, Section 49.1. As you are likely aware, this section requires all RM councils to enact a policy for reviewing division boundaries no later than January 2023, which is right around the corner. The policy must establish that each division of the RM has the same population or number of voters. Subject to the regulations, the policy must address the following: the council committee or other body that will undertake the review, events that will trigger a review. Some examples might be a new subdivision in one of your divisions. Additional factors to be considered to determine if a variance in population or number of voters is acceptable. Reporting of recommendations to council and the maximum time frame in which to complete a review. Requirements to make the report of the council committee or the body available for public inspection, and to give public notice of the report and any other matters council considers necessary. If council does not want to establish a policy on division boundaries, they must elect council members representing the RM at large with no reference to divisions, which is similar to the urban municipalities. Just want to keep in mind that the policy has to be completed by January 2023. The review does not have to be done. It can wait till however your policy is set up to be triggered before that review would have to be implemented. When it comes to Part 4 of the Act dealing with the creation, alteration, or restructuring of municipalities, special service areas may now be established for reasons other than just restructuring. For example, when a village restructures to become part of an RM, it was at that time where a special service area could be established so that different tax rates and different service levels could be provided within the former village. Now council can request an area to be designated as a special service area for the purpose of different tax rates and different service levels. This is required to be done by a minister's order after public notice and a public consultation process. Section 51.1 now permits cities to be included in a municipal district. Formerly, only villages, towns, and resort villages were able to join with an RM to create a municipal district. Regulating authority has also been added in regards to municipal districts. Section 89 has also been amended to allow for RMs to choose to hold elections at large, which I just mentioned, just like the urban election scheme, instead of by division. And this is in order to support Section 49.1, which is the division boundaries. Section 140.1, regarding petitions for financial or management audits, require a statement of purpose of the petition on each page. This amendment clarifies that a council may determine with the auditor the audit required to address a petition consistent with the purpose of the petition, rather than the petition being required to set out the matters for the audit. Also, provisions have been included that council may meet with the representatives of the petitioners to verify the audit addresses the statement of purpose of the petition. Within the council procedures bylaw, council must designate a person to call a special meeting in the event that the administrator is unable to or the position is vacant. This person could be named as the admin assistant, maybe your public works employee or manager, or maybe the administrator from a neighboring village or other rural municipality. This amendment is under section 81.1. Previously, in section 110, council had the ability to appoint an acting administrator if the administrator was absent. Now, with the creation of section 110.1, council must appoint an acting administrator within 30 days of the administrator being unable to act. This is to ensure regular municipal business can continue. And effective January 1st, last year, 2021, all municipalities, even those with populations under 100, are required to have qualified administrators as per the Urban Municipal Administrators Act and the Rural Municipal Administrators Act. Having a qualified administrator is one of the eligibility requirements for the municipal revenue sharing grant. Environmental improvements, section 317.3. Provisions related to environmental improvements is a new section and includes the ability to develop a program to encourage energy efficient, renewable energy, and other environmental improvements to property. The program can allow for the municipality and the property owner to enter into an agreement for the cost to be added to property taxes, and as mentioned earlier, can be added to the taxes over multiple years according to section 405.1. The next few slides that we'll be going over will cover the amendments made to the Act to increasing accountability. Inspection of municipal documents, section 117. It is now explicit that the audited financial statements and auditors' reports for controlled corporations are available for public inspection under section 117. A new subsection has also been added to clarify that a municipality may provide for additional means of making documents and records available for public inspection, including posting on a website. Normally, physical copies housed at the municipal office are available for inspection during regular business hours. Regulation making authority has also been added for the possibility of other documents to be added in the future that the public is entitled to inspect and obtain copies of. Currently, the only documents available for public inspection are those listed in section 117. Should the public request any other document, a LaFoIP request should be submitted. Regular meetings, section 122, has also been amended so that no more than 60 days may pass between regular meetings. The legislation regarding conflict of interest in section 141.1 was amended to refer to improperly further another person's private interests. This is to better align with common law, regardless if it is closely connected persons or a family member. Another important section to highlight is Section 147, as it relates to matters for disqualification. Previously, unless authorized by a resolution, a council member would be disqualified if they were absent from all regular council meetings held during any period of 3 consecutive months where at least 2 meetings were held. Now, council may adopt a leave of absence policy. Leaves for matters such as parental, bereavement, and critical illness may be better dealt with by established and standardized policies that are developed in advance, so that personal details do not need to be publicly aired through a resolution at the time a leave is sought. Amendments made to Section 148, Enforcement of Disqualification, provides council with the ability to declare a member's seat vacant who is disqualified by Section 147 but does not resign as required. The provisions also provide for the person whose seat has been declared vacant to apply to the courts for a ruling and potential reinstatement. The application must be within 10 business days after the passing of the council resolution. Section 185.1, Public Accounts, is currently not enforced, but has been added, and it will provide regulation-making authority to prepare public accounts of remuneration and expenses. The public accounts will be open for public inspection and should be available for distribution if requested by the public. These regulations will likely be legislated in the very near future and are very similar to the public account legislation required through the Cities Act. Civil liability, Section 192, has been amended so that members of council who are found civilly liable for unauthorized financial matters will not only be liable for their consequences or penalties, but are also now disqualified for 12 years. And lastly, under the theme of accountability, sections 398.1 and 399 as they relate to the ministerial authority were amended. This section now includes the authority for the minister to use and release public information that is submitted to the ministry. Investigations, reviews, and reports issued under the Saskatchewan Employment Act and by the Information and Privacy Commissioner are now added to the list of official examinations for which the minister may issue and carry out a directive. Ombudsman Saskatchewan was previously in legislation. Clarity has also been provided that the minister has the authority to include terms and conditions to grant licenses, permits, inspections, or approvals that were improperly being withheld by a municipality. Protection from reprisal. This is the next topic we will cover, and it's the newest section in the Act. This provides for explicit protection for municipal employees who report wrongdoing to a lawful authority. So, what is reprisal? Reprisal means an action taken against an employee for reporting a wrongdoing. It can be any one of the following: a dismissal, a layoff, suspension, wage reduction, change in work hours, demotion or transfer, change of job location, discontinuation or the elimination of a job, or even a reprimand, threats in taking certain measures, or discriminatory actions as defined by the Saskatchewan Employment Act. Okay, so now that we know what reprisal is, what does wrongdoing mean? The new section 114.1 also defines wrongdoing as any one of the following actions committed by a council member, member of council, or a municipal employee. contravention of a provincial or federal act or regulation, contravention of a municipal bylaw or policy, contravention of the code of ethics, rules of conduct, or procedures applicable to every member of council that is imposed by the Municipalities Act and by council, an act or omission that creates substantial danger to life, health, or safety of persons, or substantial and specific danger to the environment, gross mismanagement of public funds or a public asset, knowingly directing or counseling someone to commit a contravention, an act, or an omission mentioned in the above. More specifically, the Act now states that no person shall take or direct a reprisal against a municipal employee because the employee has, in good faith, sought advice about making a disclosure of wrongdoing or made a disclosure of wrongdoing. This includes to employment standards, the ombudsman, an auditor, and law enforcement, participated in a review or investigation of a wrongdoing, or declined to participate in a wrongdoing. So what happens if a reprisal occurs? Ultimately, it is up to the employee to determine the course of action they wish to pursue. The employee may consider filing a complaint through the Code of Ethics bylaw if the alleged reprisal involved council or members of council. They may also consider pursuing it through the municipality's whistleblowers bylaw. Although keep in mind, the whistleblower bylaw is not mandatory. However, it may be something that your municipality considers putting in place. We have a sample bylaw available on saskatchewan.ca, as well as a whistleblower protection guide for more information. Municipal employees still have rights and protection from reprisal under provincial and federal legislation, such as the Saskatchewan Employment Act and the Criminal Code. The employee that has been reprised against may also speak with labor relations and workplace safety, and ultimately, the employee may consider getting legal advice. Penalties for reprisal. The penalties for a municipal employee or member of council are enforced upon summary of conviction, which is consistent with the general offense and penalty provisions of the Act. Members of council can also be personally liable if they vote in favor of authorizing a reprisal action to be taken against an employee. Council members who contravene this new section are also subject to the reasons for disqualification found under Section 147 of the Act. Every person who takes or directs reprisal against a municipal employee for disclosing a wrongdoing is guilty of an offense and liable on summary of conviction to, in the case of an individual, a fine of not more than $10,000 or imprisonment for not more than 1 year, or both. In the case of a corporation, a fine of not more than $25,000. And in the case of a continuing offense by an individual or a corporation, to a maximum daily fine of not more than $2,500 for each day or part of a day during which the offense continues. So those are pretty hefty. Next, we'll move on to amendments made to the Act that increase the use of more informal collaborative dispute resolution processes. Section 8, bylaws, now includes provisions for municipalities to include dispute resolution or mediation requirements within their bylaws. This type of provision encourages collaborative solutions before legal and court actions are taken. Disputes related to vehicle weights or route designation may now be submitted to the Saskatchewan Municipal Board, which is consistent with existing legislation regarding disputes for road maintenance agreements. In these cases, the parties may resolve a dispute by themselves or by agreeing to an adjudicator. Failing those options, either party can now refer the matter to the Saskatchewan Municipal Board. The Saskatchewan Municipal Board has the authority to handle specific matters set out in the Municipalities Act that require regulatory approval or dispute resolution. Organized hamlets. Many of you RMs have organized hamlets and are likely familiar with this next amendment that was made. Under Section 77, when a dispute occurs between an organized hamlet board and RM Council regarding the appointment of a third member to the appeal board, either appointee can refer the matter to the Saskatchewan Municipal Board. The Saskatchewan Municipal Board will then handle the dispute regarding the appointment of the chair under the process outlined in Section 392. Under Section 392, the Saskatchewan Municipal Board shall appoint a mediator to assist the parties in resolving a dispute before holding a hearing and making a decision. If mediation fails, the Saskatchewan Municipal Board will hold a hearing and make a decision. Such matters where compulsory dispute resolutions is required are agreements with other municipalities regarding public utilities, intermunicipal sharing of taxes and grants in lieu of taxes, municipal restructuring, responsibility for auditing an intermunicipal body, road harmonization or weight, the appointment of the third member of the appeal board for the OH-RM dispute, as mentioned above, and vehicle weights or route designation. Lastly, when it comes to amendments related to dispute resolution, under Section 394.2, the minister has the authority at any time to refer a dispute involving one or more municipalities to the Saskatchewan Municipal Board to hold a hearing to settle the dispute. Amendments to Section 394.2 allow the minister to refer disputes, not only intermunicipal, to include situations where a dispute involves municipalities and a third party. The other areas that received some significant amendments were to assessments, Board of Revision, and taxation that we'll go over in the next few slides. Assessment. When it comes to the assessment roll, it is no longer required under Section 116 to be a permanent record of the municipality. It must be preserved for a minimum of 10 years or any longer period established in your records retention and disposal bylaw. Council may wish to amend the records and retention bylaw to reflect this new period if you haven't done so already. For municipalities with non-producing petroleum, oil, or gas wells, the cutoff date for non-production is now July 1st of the previous year rather than September 1st. Under Section 215, the assessment notice must include both the contact information for the municipality and the contact information for the Secretary of the Board of Revision. The assessment appeal fees approved by Council must also be included. Provisions related to the simplified appeal process were also amended in Section 223. The assessment value thresholds that previously existed in the Act for parties to pursue a simplified appeal process will now be in the regulations, making it easier to adjust if necessary and to reflect and be current with property values and assessments as a result of revaluations and market conditions. And whether it's an agreement to adjust, a decision of the Board of Revision, or a decision of the appeal board at the Saskatchewan Municipal Board, if the property owner is not party to the appeal, the property owner must be notified of the agreement or decision. That's under sections 228, 240, and 256. Matters related to boards of revision were also addressed. It is now explicit under Section 220 that boards of revision members must be appointed by council prior to the preparation of the assessment roll. Members of council and employees of the municipality are not eligible to sit as members of the Board of Revision. Regulation making authority was added to Section 221, Secretary of the Board of Revision, concerning appointment, remuneration, and duties of secretaries of boards of revision to accommodate future improvements and clarification regarding the role of the secretary. A new section, 221.1, was added that provided regulation making authority for the minister to establish a provincial office of the registrar. This provincial registrar may receive, review, and process appeal notices prior to sending to boards of revision for scheduling hearings and completing the remainder of the appeal process. Section 226 was amended to clarify that secretaries of boards of revision are not only required to notify the appellant that their notice of appeal is deficient, if the case may be, but they are now required to explain the deficiencies to the appellant. And just want to make note, Section 221.1 is not in effect as of yet, where the provincial registrar receives and reviews and processes appeal notices. Section 238 has been amended to clarify that if any part of the Board of Revision appeal hearing is recorded, a written transcript must be made by a court reporting service. A significant change that many boards of revision will find helpful is that under Section 240, they now have 180 days to issue their decision. Remember, the 180 days is counted from the date that the assessment roll is advertised in the Gazette. And lastly, the Secretary of the Board of Revision must provide any records requested by the Appeal Board Secretary at the Saskatchewan Municipal Board within 14 days. Just a little note, court reporting service is verbatim records to be produced. So the service would probably digitally record the hearing and provide transcripts. Moving on to amendments related to taxation. Just like assessment roll records in Section 116, tax roll records are no longer required to be a permanent record. They too must be preserved for a minimum of 10 years or any longer period that Council has provided for in the municipality's record retention and disposal bylaw. Section 293 was amended as it relates to the tax exemption applied to dwellings in RMs. Dwellings located in hamlets are no longer eligible to receive a taxable exemption due to the owned or leased agricultural land of the occupant. This amendment will treat residences in hamlets the same as organized hamlets and special service areas, which were already excluded from the exemption. Lastly, for any of you RMs that have a bylaw requiring a permit for trailers or mobile homes in lieu of taxation, the minimum number of trailers on the property to require a permit was reduced from 2 to 1. The final items that we will go over in the next 3 slides are miscellaneous clarification matters. Sorry, I had to clear my throat there. I'm getting croaky. Section 8 was amended to clarify the costs of regulating activities for the purpose of setting fees, and they may include the cost of enforcement of the regulatory scheme for the license or permit. Also, a clause has been added to clarify that municipalities do not have the authority to pass any new bylaws respecting firearms unless provided for in the regulations. Section 111 clarifies that it is the administrator's responsibility, unless otherwise provided by council, for the hiring, suspension, and dismissal of all municipal employees. We get a lot of calls about this lately. This section also received an addition in that the administrator can witness any oaths or affirmations that are required by the Act. This addition simply aligns with the Legislation Act, which requires that a person who administrates an oath is named in the Act that the oath falls under. When it comes to tax payments, Section 273.1 has been added to clarify any payment or collection of taxes received must be apportioned amongst all taxing authorities, whether or not the payment received is characterized as a tax payment. Regulation making authority has also been added to this section if further clarification is needed in the future as well. The Act now includes that the mill rates return survey must be submitted to the minister by August 15th of each year. Clarity has also been provided in Section 292 that the First Nations have the same property tax exemption for buildings and land used for school purposes as do other school divisions. Throughout sections 68 to 78, clarification was added in the legislation about organized hamlets. It has been made clear that an organized hamlet board is a recommending body to council. Clarity was also provided that money from the organized hamlet account can be used for any purpose that is included in the budget. Regulation making authority was also added to address hamlet budget and reporting activities and how conflict of interest legislation applies to organized hamlet board members. As mentioned at the beginning, the additional resources can be found regarding these amendments on our website, Chapter 30, the Miscellaneous Municipal Statutes Act and the Municipalities Act, Bill 194 Amendments Bulletin. That concludes my brief presentation, which touched on some of the amendments contained in Bill 194. To discuss any of these amendments in depth, please contact our Advisory Services Inquiry line, and any of us advisors can discuss these topics with you further. Guess now we can I'll turn it back to Colin.
Excellent. Thank you so much, Chris. That was really informative. I'm just looking to see if we have any questions. Just looking in the Q&A, and I don't see any just yet. Okay, the question is the recording going to be distributed? I think Adam can answer that. Yes, we will be providing that copy, I believe. The section regarding employees and the administrator's power to hire, fire employees. If we have approved council to be the employer of the public works foreman, would the responsibility of the public works foreman fall under council or the administrator?
So it would depend on how that's laid out. If it, you could if it's in a policy or a bylaw, I would just make sure that it is specific as to what the responsibility of council is for that. Ultimately, council's supposed to kind of have a hands-off approach to the employee perspective. However, if it's directed and laid out in a policy, that's what would have to be followed.
Okay.
Yeah.
Is it possible for the government of Saskatchewan to develop an updated records for retention disposal guide? The last one was 2016.
Yeah, I know. I thought this when I was in the field too. We brought it up, so hopefully we'll be able to get something going on that. It doesn't fall under government relations, but it's definitely been talked about.
Okay. Can a ratepayer come in and just request payment to hail only?
That I have to look in the legislation. So I saw which RM popped that in, so I can get back to them on that one.
Excellent. Okay.
Yep.
Let's take a look. Uh, if I guess this carries on to uh, council members, if they hire and fire, example, the foreman or outside staff, are they then considered their supervisors for OH&S purposes?
They would have to clarify that with OH&S. I can't speak to how they would interpret that under that type of legislation. Hope
Okay.
that answers that.
Yes. Okay. There's a few more questions popping here. Just bear with me while Adam dumps them into the Q&A section.
Mm.
How does the 1971 assessed values that we often get requested for by accountants fit into the retention of assessment roll and tax roll information?
I need to read that one for a second here. Just see if I can find it. How do
So, yeah.
keep requested by for accountants fit into retention of that one I'll have to look into as well. I'm not sure I totally understand that question in full. So I can give them a call about that in
Okay.
Torch River. Yeah.
Okay. The question is, let us all know about distribution of tax collections.
I
Not
don't
sure.
know I would have to look back in legislation to see the exact percentage. Um, but that is under the section is referenced there. Um, Go back here. I'll get back to them on that one as well. I don't know exactly the percentages. It just has to be applied evenly to both school and municipal. You can't just apply the payment to one and not the other. Same as if it's a prepayment, but if they want to give us a call, we can go over that with them.
Okay, sounds good.
Yeah.
Another question here on divisional boundary policy. Based on the Act, Council doesn't need to adopt the new divisional boundaries. Does this mean they can keep the same boundaries even if they are widely different in population?
So you would have to determine that within your policy. That's the purpose of the policy is to even out the voter or population disbursement for effective electoral purposes. Um, they need to adopt the new boundary policy. They don't have to trigger a review as of yet at this point. So in that policy, it would have to determine what would trigger that review. So, um, maybe by completing the policy, it's going to trigger this review to have a look at the boundaries.
Great, thank you for that.
Mhm.
The one that popped into the chat here right away.
Population numbers in each division. You
Yes.
would,
Yeah, the question is, do you have any suggestions on how to figure out voter or population numbers in each division?
your it would just be your best estimates that you would be able to do. Um, I guess you could have a look at the most recent census and kind of go from there. If you have any, clusters of subdivisions, you might have a good idea of how many voters might live there. I know it's very hard to determine, especially if people's children are living at home and they're 18, they're eligible to vote as well. It's ultimately, you do your best. So that's not a very good suggestion, but that's all I can really say.
Okay, a follow-up question to the boundary question previously. If the policy gives council the choice to approve or reject new divisional boundaries, the act doesn't necessarily force them to approve the new boundaries.
Correct, and that's, I have a feeling that's where we will start to see once these reviews start being played out, and if boundary changes do need to be done, we'll see more legislation come in through the regulations to start maybe, I wouldn't say enforcing because we don't, municipalities are their own level of government and are responsible. So um, you may start seeing that these reviews have to be submitted to the minister periodically or that sort of something like that.
Okay, so I don't see any other questions for you at this time. Um,
Perfect.
so once again, thank you so much, Chris, for taking your time and going over this important information for the membership. And I, like I said earlier, wish everybody a wonderful day and stay nice and warm. Get out and do some ice fishing if you fish. So,
Awesome. Thanks for having me.
alrighty, all right, take care.
Okay.